Many parents over the age of 65 believe that adding an adult son or daughter to their checking or savings account is a simple, smart way to plan for the future. It seems like a common sense decision. If you get sick, if you are hospitalized, or if you simply need help paying the monthly utilities, your child can sign the checks or use the debit card on your behalf. It feels like an act of love and preparation. But beneath this everyday convenience lies a hidden financial trap that most families discover far too late. The moment you place an adult child's name onto your bank account as a joint owner, you are not just permitting them to help you with the bills. In the eyes of the law, and in the eyes of the bank, you may have just handed over half of your hard-earned savings to their future financial problems. If that child gets into a car accident, goes through a bitter divorce, faces a business bankruptcy, or falls behind on their taxes, the money in your bank account could be frozen, seized, or legally divided by outsiders. A lifetime of careful saving can disappear because of a mistake made by a child who meant you no harm. Over the next 30 minutes, we are going to look closely at what actually happens when you share a bank account with an adult child. We will look at why a joint account behaves very differently than you think, how it can accidentally disinherit your other children, and how it can even jeopardize your future medical benefits or create an unexpected tax bill. More importantly, we will discuss the safe, legal alternatives that protect your independence while ensuring your family can always help you when you need it most. This matters because your bank account is often the front line of your daily financial security. When we talk about estate planning, we often focus on the big pieces, like the family home, a life insurance policy, or a traditional IRA. But your checking and savings accounts are where your Social Security checks arrive, where your pension is deposited, and where the money you need for groceries, prescriptions, and property taxes sits every single day. When a senior citizen loses access to a bank account, even for a few days, their entire life can be thrown into chaos. If an account is frozen because of an adult child's legal troubles, automatic payments for your supplemental health insurance can bounce. Your utilities can be threatened. The peace of mind you spent 40 years building can evaporate in a single afternoon. We live in an unpredictable world, and even the most responsible adult children can face sudden, catastrophic financial setbacks. A medical emergency, a failed business partnership, or a sudden legal judgment can bring creditors knocking on their door. If your name is joined with theirs on an account, those creditors do not see the money as yours alone. They see an asset they can legally target. By understanding the true mechanics of joint bank accounts, you can prevent a well-intentioned family arrangement from turning into a legal nightmare. You can protect your children from inheriting a paperwork disaster, protect your spouse from losing access to funds, and protect yourself from unnecessary financial vulnerability. To understand why this is so dangerous, we have to look at the simple explanation of what a joint bank account actually is. When you walk into a financial institution and add your adult child's name to your account as a joint tenant with right of survivorship, you are not simply giving them a password or a signature card. You are changing the legal ownership of that asset. In most jurisdictions, a joint account means that both parties own 100% of the account. Both of you have an equal, undivided right to withdraw every single penny at any time, without the permission or knowledge of the other person. Here is the hidden danger that most people miss. Because the law views your child as a full owner of the account, the child's financial history becomes permanently linked to your savings. Most seniors assume that because they deposited every dollar into the account from their own pension or Social Security, the money remains exclusively theirs. They believe that if a problem arises, they can just explain to the bank or a judge that the child was only added for convenience. But the legal system does not work on intentions. It works on signed documents. The signature card you signed at the bank overrides your private intentions. If your child faces a financial judgment, the burden of proof is on you to legally prove that the money belongs solely to you, a process that can take months and cost thousands of dollars in legal fees while your account remains frozen. Let us look at a realistic example involving a retired nurse named Eleanor, who is 72 years old. Eleanor wanted to make sure someone could manage her finances if she ever became ill. She took her oldest son, Robert, to her local bank branch and added him as a joint owner on her main checking and savings account, which held $65,000 of her life savings. Robert was a responsible man, a school teacher with a family of his own. Eleanor felt relieved knowing Robert could sign checks if she was ever hospitalized. 2 years later, Robert's wife unexpectedly filed for divorce. During the divorce proceedings, the attorneys demanded copies of all bank accounts bearing Robert's name. When they discovered Eleanor's account, the opposing attorney argued that the $65,000 was a joint asset accessible to Robert, and therefore subject to division or consideration in the marital settlement. The consequence for Eleanor was devastating. Her account was not immediately seized, but it became tied up in a bitter legal dispute. Her personal financial privacy was destroyed as stranger lawyers picked through her monthly spending habits. She had to hire her own independent attorney to file motions proving that Robert had never deposited a single dollar into that account. While the lawyers argued, Eleanor lived in constant fear that her access to her own money would be restricted. The stress alone took a heavy toll on her health. wealth. To avoid this, you must understand that banks do not have a standard convenience account option in most states. When you add a name, you are adding an owner. Before you sign any paperwork at a financial institution, you must ask the representative exactly what form of ownership is being created. If the phrase joint tenants with right of survivorship is on the document, you are entering a high-risk zone that links your financial life to your child's liabilities. The next mistake is quiet because nothing looks wrong until your family suddenly needs the money. Many seniors believe that if their adult children are honest and responsible, there is nothing to worry about. They trust their children completely, and rightfully so. But this issue is not about whether you trust your child. It is about whether you can trust the unpredictable external forces that can affect your child's life. The hidden danger here involves third-party creditors and legal judgments. If your adult child is involved in a serious automobile accident where the damages exceed their auto insurance policy limits, the injured party can sue your child personally. If a judge grants a financial judgment against your child, the collection attorneys will immediately run a comprehensive asset search. They will locate every single bank account that carries your child's social security number. When a creditor finds a joint bank account, they do not pause to ask who deposited the money. In many states, the creditor has the legal right to slap a freeze or a levy on the entire account. The bank is legally required to comply with the court order. Overnight, your checking account can be locked, your outstanding checks can bounce, and your automatic bill payments will fail. Consider the case of a retired electrician named Frank, who was 78. Frank added his adult daughter Sarah to his savings account containing $40,000, which he kept as an emergency fund for unexpected medical costs or home repairs. Sarah ran a small independent bakery. A few years after her name was added to Frank's account, her business suffered a severe downturn, and she fell significantly behind on her state and federal payroll taxes. The tax authorities issued a levy against Sarah's tax identification number. Because her social security number was attached to Frank's savings account, the government seized $35,000 directly from Frank's account to satisfy Sarah's business tax debt. Frank received no warning from his bank. He discovered the seizure only when he went to withdraw money for a dental procedure and found his balance nearly wiped out. The consequence in this scenario is a direct loss of capital with very little legal recourse. Because the IRS or state tax agencies have vast collection powers, recovering funds seized from a joint account is extraordinarily difficult, even if you can prove the parent was the sole contributor. The law often presumes that by adding a child's name, you made a completed gift of those funds to the child, making the money fair game for the child's creditors. To protect yourself, you must recognize that your savings should never be exposed to the business risks, professional liabilities, or personal debts of your children. If your child works in a high-liability profession, owns a business, or has a history of financial instability, adding them to your account is an immediate hazard. Review your accounts this week to ensure your child is not listed as a co-owner. If they are, you need to speak with a professional about removing them safely without triggering other legal or tax complications. This is where the paperwork becomes more powerful than the family promise. Many parents have a clear, heartfelt plan for what should happen to their assets when they pass away. They might write a beautiful, detailed last will that says everything they own should be divided equally among their 3 children. They assume that this will govern everything. Here is the part most people miss. A joint bank account with right of survivorship completely bypasses your will. It is a contractual agreement that sits above probate court. When a joint owner passes away, the surviving owner automatically becomes the sole owner of the entire account by operation of law. It does not matter what your will says. It does not matter what you told your children at the Thanksgiving dinner table. The bank contract always wins. The hidden danger is that parents often add the local child, the son or daughter who lives nearby, to the account so they can help with the shopping and banking. The parent expects that when they die, that local child will take the remaining money in the account and split it evenly with their siblings. But legally, that child has no obligation to do so. Even if the child wants to split the money, doing so can create unexpected gift tax filing requirements or cause interpersonal friction that damages the family permanently. Let us look at a realistic example involving a widow named Margaret, who passed away at age 84. Margaret had 3 adult children who loved each other dearly. Her daughter Linda lived just 10 minutes away and managed Margaret's doctor's appointments, groceries, and bills. Margaret's 2 sons lived in another state. To make things easy, Margaret added Linda as a joint owner on her primary bank account, which held $90,000 at the time of Margaret's death. Margaret's will explicitly stated that all her assets, including all bank accounts, were to be divided equally among her 3 children. However, upon Margaret's death, the $90,000 legally belonged entirely to Linda. The bank immediately removed Margaret's name and handed full control to Linda. The consequence was a heartbreaking rift in the family. Linda's brothers expected their $30,000 shares heirs as outlined in the will. Linda wanted to honor her mother's wishes, but her husband was facing heavy medical bills of his own, and he pressured Linda to keep the money, pointing out that it was legally hers and that she had performed all the work of caring for their mother for years. Linda hesitated, communication broke down, and the brothers came to believe that Linda had manipulated their elderly mother. The brothers stopped speaking to Linda, destroying the family unity that Margaret had spent her entire life protecting. This kind of family tragedy is entirely preventable. If your goal is to have your assets divided equally among your children, using a joint bank account as a management tool is one of the worst decisions you can make. It forces one child into a difficult moral and legal dilemma and breeds deep resentment among siblings who feel excluded. If you want a child to help you manage your money, you must use tools that do not grant them survivorship ownership rights. Before you change anything, you need to understand why the usual advice can backfire, especially when it comes to long-term care planning. Many seniors are aware that long-term care in a nursing home or assisted living facility can be astronomically expensive. They know that Medicaid is a federal and state program that can help pay for these costs, but only after an individual has met strict asset limitations. What many seniors do not realize is that Medicaid has a strict 5-year look-back period in most states. When you apply for Medicaid to cover nursing home care, the caseworkers will audit every financial transaction, bank statement, and property transfer you made over the previous 60 months. They are looking for any instance where you gave away money or assets to qualify for the program. Here is the hidden danger regarding joint accounts. If you add your child's name to your bank account within that 5-year window, Medicaid may view that action as a transfer of assets or a gift, especially if the child withdraws any funds from the account. Even worse, if your child places their own money into your joint account to help pay for your expenses, Medicaid may count that entire account as your asset, potentially disqualifying you from benefits because your balance appears too high. Let us consider a retired school teacher named Thomas, who was 76 years old. Thomas began experiencing early stages of cognitive decline. His daughter Karen moved into his home to care for him. To simplify their life, Thomas added Karen to his savings account, which held $50,000. Over the next 3 years, Karen used the account to pay Thomas's mortgage, buy his groceries, and occasionally withdraw a few $100s to cover her own gas and minor expenses as compensation for her caregiving time. At age 79, Thomas's condition worsened significantly, requiring specialized care in a skilled nursing facility. Karen applied for Medicaid on his behalf. The Medicaid caseworker demanded 5 years of bank statements for the joint account. When they reviewed the records, they flagged every single withdrawal Karen had made for her own use as an uncompensated transfer of assets, a gift. They also treated the entire $50,000 as Thomas's personal asset, refusing to deduct the portions Karen had contributed from her own part-time job. The consequence for Thomas and Karen was a lengthy penalty period, during which Medicaid refused to pay for Thomas's nursing home care. Karen was forced to pay the facility out of pocket, using her own limited savings, while struggling to appeal the state's decision. The stress was overwhelming, and Thomas's care was nearly interrupted because of a banking arrangement they thought was completely legal and helpful. The rules governing Medicaid are intricate and vary significantly from state to state. Do not make the mistake of thinking that a joint account is a clever way to hide or protect money from the government. The state will dismantle these arrangements during an audit. If you anticipate needing long-term care assistance within the next 5 years, your banking structures must be designed with the explicit guidance of an elder law attorney who understands your state's specific regulations. The next risk involves the Internal Revenue Service and the hidden tax consequences that families rarely consider until they receive a formal notice in the mail. When you add someone to a bank account, you might be triggering federal gift tax reporting requirements without ever realizing it. Under IRS rules, if you add an adult child to a bank account and that child withdraws funds for their own personal benefit, that withdrawal is legally considered a gift from you to the child. If the amount withdrawn exceeds the annual gift tax exclusion limit in a single year, you are legally required to file a federal gift tax return. While you may not owe actual taxes due to the high lifetime estate tax exemption, the failure to file required paperwork can lead to future complications and audits. Furthermore, there is the issue of income tax on the interest earned by the account. When an account earns interest, the bank issues a Form 1099-INT at the end of the year. This form is typically tied to the primary Social Security number listed on the account. If the bank sends the 1099 under your child's number, your child is now responsible for reporting that interest on their personal income tax return, even if they never touched a dime of the money. If they are in a higher tax bracket than you, your family is now paying more tax on that interest than necessary. Let us look at a retired mechanic named Arthur, age 74, and his daughter Megan. Arthur had a high-yield savings account containing $150,000, which generated a substantial amount of interest each year. He added Megan as a joint owner so she could manage the funds if he ever had a stroke or a medical crisis. The bank processed the paperwork and mistakenly placed Megan's Social Security number as the primary identifier expire on the account. At the end of the year, the IRS received a copy of the 1099-INT showing thousands of dollars in interest income under Megan's name. Megan, who was working hard to build her career and was already in a high tax bracket, did not realize the mistake and failed to report this interest on her tax return. The consequence arrived 2 years later in the form of an IRS automated underreporter notice sent to Megan, demanding back taxes, interest, and penalties for unreported income. Arthur was deeply upset that his savings had caused his daughter a tax headache. They had to spend hours working with a certified public accountant to amend tax returns, draft explanatory letters to the IRS, and correct the registration at the bank. It was a costly, frustrating distraction that could have been completely avoided. This is why the technical setup of your bank accounts matters. You must always know whose social security number is linked to the tax reporting of the account. Never assume the bank staff will automatically configure things the way you expect. You need to verify the tax reporting status of every account you own, especially if you have shared access with a family member. Now, before this sounds overwhelming, here is the good news. You do not have to leave your family unprotected, and you do not have to navigate your finances alone. There are safer, more elegant legal tools designed specifically to give you the help you need without exposing your hard-earned money to unnecessary risks. Let us walk through a clear, practical checklist of what you should check, ask, and adjust this week. Step 1. Perform a comprehensive bank account audit. First, make a list of every bank account you own. This includes checking accounts, savings accounts, certificates of deposit, and money market funds. Look at your most recent statements or log into your online banking portal to see exactly whose names are listed on those accounts. If you see an adult child's name listed alongside yours, look for the specific designation. Is it listed as a joint owner, or is it listed under another format? If it is a joint account, write down the name of the child and the purpose that account serves in your daily life. Step 2. Understand the power of attorney alternative. If your primary goal is to ensure that your child can sign checks, pay bills, and manage your money if you become sick or incapacitated, the correct tool is a financial power of attorney, not a joint bank account. A power of attorney is a legal document where you grant your child the authority to act as your agent. When your child uses a power of attorney at the bank, they are acting on your behalf, but they do not own the money. The money remains entirely yours. Because your child is not an owner, their personal creditors, divorcing spouses, or tax liens cannot touch your account. Furthermore, a power of attorney creates a fiduciary duty, meaning your child is legally required to use the money only for your benefit, protecting you and keeping the family accounting transparent. Step 3. Implement payable on death (POD) designations. If your main goal is to make sure your child inherits the money quickly when you pass away, without going through the lengthy and expensive probate court process, you should use a payable on death (POD) designation, also known in some states as a transfer on death (TOD) account. You can walk into your bank and ask to add a POD beneficiary to your existing accounts. You name your children as beneficiaries. While you are alive, your children have zero access to the account. They cannot withdraw money, they cannot see your balance, and their creditors cannot touch a single dollar. But the moment you pass away, your beneficiaries can present your death certificate and their identification to the bank, and the funds will transfer directly to them outside of probate, exactly as you intended and in accordance with your wishes. Step 4. Investigate convenience accounts, if available. In some specific states, financial institutions offer what is officially called a convenience account or an agency account. This is a special type of account structure recognized by certain state laws where you add a person to the account strictly for the purpose of signing checks and making deposits, without granting them any ownership rights during your life or any survivorship rights after your death. Ask your specific bank branch manager if this option is legally available under your state's banking regulations. If it is, it can be a simple way to achieve your goals without a complex legal document. Step 5. Consult with an estate planning or elder law attorney. Rules can vary significantly by state, so do not change a deed, a bank title, or a beneficiary form based only on a video. Use this information as a checklist of what to review with someone qualified. An experienced estate planning or elder law attorney licensed in your state can look at your entire financial picture, your home, your savings, your health status, and your family dynamics, and draft a coordinated plan. They can help you create a comprehensive strategy, which might include a revocable living trust, ensuring that your daily banking remains seamless while your long-term protection is ironclad. To summarize what we have discussed today, adding an adult child's name to your personal bank account as a joint owner is a high-risk gamble disguised as a simple convenience. While it feels like an easy way to prepare for potential health challenges or to assist with daily management, it opens a dangerous door. It legally links your life savings to your child's personal, professional, marital, and financial liabilities. We looked at how a joint account means that both parties legally own the funds, which can allow a child's creditors, lawsuits, or divorces to freeze or seize your money. We We discussed how joint accounts override your last will, creating a serious risk of accidental disinheritance and destroying family harmony among siblings. We examined the severe complications this can cause with Medicaid look-back audits and unexpected IRS interest tax reporting errors. Please remember not to panic. If you have already added a child to your account, this is a common step that millions of well-meaning families take. The important thing is that you now know the risks and you have the power to fix it. By transitioning away from joint accounts and instead utilizing protective legal tools like a financial power of attorney and payable on death designations, you can maintain total control over your money, keep your family protected, and ensure that your retirement savings remain secure for exactly what you need. Your financial peace of mind is worth protecting, and taking these small, practical steps this week can save your family from an administrative and emotional nightmare down the road. Tell me which one you want explained next. Bank account titles, beneficiary forms, durable powers of attorney, Medicare rules, or Social Security survivor benefits. Leave your choice in the comments section below as I read through them to decide which critical senior protection topics we will break down next. If you found this guide helpful and straightforward, please share this video with the person in your family who helps you keep the paperwork, or with a friend who might be considering making this exact banking change. Thank you for your time. Stay vigilant and take care of yourself.